Retirement for Life. Your passport to a comfortable and confident retirement. The podcast that's equal parts education and entertainment, where we break down the retirement maze with a dash of fun and a heap of wisdom from your host, Christian Sear CPA, the passionate retirement specialist and president of Sear Financial Wealth Advisors, the independent registered investment advisor specializing in the Aim Retirement System.
Welcome back to the Retirement for Life podcast. How you guys doing?
Good. How are you?
Good. Today we're talking about your legacy, securing your legacy, and we're going to cover a lot of estate planning essentials. We have self-proclaimed May as Estate Planning Awareness Month at Sear Financial.
I did. I self-proclaimed May Estate Planning Month, but I was told by Brooke that
It's October.
So what happened was I put out a client letter this month, client video, and I really explained why we wanted to focus on trusts, wills, estates, things like this. And I declared it Estate Planning Awareness Month, and I was promptly told that it was wrong. So for us, May is Estate Planning Month.
Well,
so we're
maybe
going to
that
talk
just
about
means
today.
everyone will be all set by October.
Yeah, there
which
we
is
go.
Actual estate planning month.
So,
We can celebrate it
here's the
twice.
thing about this episode. The majority of people who are retired do not have their estate documents in proper order. I would say 50% of people think they kind of do, but don't understand the importance of it.
Yeah.
Some people have their things in order, but the majority of people do not, and that's what this episode is for. And I think we're going to make it fun because we have made it into a game.
Yep. Yeah, we have a game. It's called Will You or Won't You?
Get
We're
it?
going to be talking about wills today and trusts and things you might need later in life. So we're going to start with the game.
So we're going to play the game, and then afterwards we're going to hit a few topics, and then you'll be out of here in, let's just say 20 minutes.
Yeah.
'Cause that's what I like to say.
Yep.
All right, let's get started with the game. What's the first question?
All right, true or false? If you don't have a will, the state gets all my assets.
We hear this a lot, actually, like that people are nervous that they are going to go through probate.
Yeah.
So,
Yep.
We should say that we're not lawyers, so we're not giving any recommendations, but this is our experience, and we're just kind of talking about what we think and what we've seen. I personally, I just talked to Brooke today. She's been at the firm for 9 years. Andrew's been here for 14 years. I've been a CPA since 1997, so it's kind of funny how you have these rules that you say, I'm not an attorney, so I can't tell you what to do, but literally I've been there for 30 years. You do not have to worry about your assets going to the state, right?
right.
What actually happens
So
if
it's
you don't have a
it's
will?
going to go through a process called probate, but that doesn't mean that the state takes your assets. They're going to do their best to, give your assets to your beneficiaries, whoever they can find. That's why it's important to have a will to state your specific wishes, where you want everything to go.
Yeah, imagine a judge just deciding everything about your life. Is exactly what probate court is.
Yeah.
If you have a will, the judge says, does this person have a will? And if you say, yes, judge, there was a will, he looks at the will, they review the will, and if it looks reasonable, there's no debts outstanding, he will follow the instructions of the will.
Right.
So I always give the example of you have two kids, all right? Person A has a will, and it says, I want to split my assets 50-50. The judge looks at the will and says, yeah, 50-50. But what if that person doesn't have a will? What's the judge maybe going to say if you don't have a will?
They're going to want to know if they have any kids.
Yeah. And so a lot of times I've told people, look, if you don't have a will and you have a pretty simple situation, perhaps the judge is just going to do what your will is going to say anyway. But there's a lot of reasons that you shouldn't just leave it up to a judge, right?
Yep.
So no, the state will not get your assets. Is that correct?
Correct.
Right.
But you should have a will.
Yeah.
What's question number 2, Brooke?
This is multiple choice. Which of the following assets does not pass through your will? A, your house. B, your 401k with a named beneficiary. C, your coin collection. Or D, your baseball cards.
Okay, so let's tee this up. People sometimes think that everything they own in their entire life, everything on their net worth statement, everything on their balance sheet is dictated by the will. That is false.
Right.
there are assets that people have that do not go through your will. Typically, those assets have a beneficiary tied to them.
Yep.
So what were the 4 choices? Which one of these is not in your will?
Your house, your 401k with a named beneficiary, your coin collection, or your baseball cards.
What's the answer?
The 401k will not go through your will. Anything with a beneficiary. So life insurance, IRAs, 401k, typically you name a beneficiary. Importantly, make sure you have a beneficiary named, because that happens a lot that people just forget or don't double check.
So like, what's a good example? You have an old 401k plan. You were single all your life. And all of a sudden you decide to get married. Something happens to you. You have a will. It says, the 2 kids get things 50-50 or whatever it is.
Yep.
But you forgot about the 401k, which is not covered under the will. To your point, make sure you update your beneficiaries.
Yep.
Lesson there, Brooke, not everything goes through the will. Only some things go through the will. What's the next question?
True or false? Naming your minor child as a beneficiary is a good way to leave them with money directly.
Is that not common sense?
No.
Let me leave my millions to a 10-year-old. Does that make sense to anyone?
I know. And you can name them, but you need to note that you're naming a minor, and you need to have a will in place for what's going to happen with that. So
There has to be someone, willing to help the child manage the assets. Otherwise, there would be no choice but to, have the state step in and manage the assets, which is, it's not ideal. You want to name a custodian if there's a minor.
There's an important distinction point. Typically, wills are a good first step. They dictate what happens the day you die. But they speak nothing and cannot speak anything to what you want to happen to your stuff 10 days after you die, 10 weeks after you die, 10 years after you die. A great example is if you have a 10-year-old, a will may not be the best tool to dictate what you want to happen with those assets for the next 20, 30 years of your child's life. A trust, what does a trust do? It kind of can dictate things in the future past the date of death.
Yep.
Yeah, whether it's a minor or, a child that you don't think has responsibility, is not old enough, or whatever the case may be, special needs even. If there's a specific situation where you want to help dictate what the assets do when you're gone, then you might need something like a trust.
So I think this is a good distinction also. When people are thinking about wills and trusts, we just made a good point. Trusts have a little bit more functionality, can look a little bit further into the future. Really a flexible tool to give you options and spell those out so that a trustee can make sure that your wishes continue on past your death.
Yep.
So if I'm going to an attorney and I have the most simple vanilla case, maybe the attorney will decide you just need a will. You have a simple case. You have 2 kids. I'm going to give kid A 50% and kid B 50%. You say that sounds good. I'm going to get a will. But if you start to describe some unusual situations, and how often do we ask a lot of questions and unpeel that onion and all the layers start, and then you find out about, we just had a meeting today, we found out about 6 or 7 properties we didn't know about.
And it's like, I want my assets to be split evenly between my kids. But then the more you dive into it, maybe there's, a specific situation where so-and-so gets this, and I don't want so-and-so to have this until they're 25. It really depends on the situation. So the more complex, typically that means, you'll need more than just a will.
Yep.
Yeah. And the other thing about wills versus trusts, since we're on the topic, is this idea of probate, right? We were talking earlier about a judge deciding who gets your stuff. If you have a will, it makes it easier for the judge to decide who should get your stuff. But either way, it's a court process.
Yep.
Either way, there are court costs. Either way, there are lawyers involved. Either way, this is taking time and money. And either way, it can be a burden. A trust, any asset in a trust will bypass the probate process. And that can be nice for people, especially a lot of cases we have what? We have a home. How long does it take to sell a home, make sure everyone's paid, make sure the mortgages pay off, make sure that if you have your home, for example, in a trust, you don't have to do anything with that. How about this situation? I have a situation right now in my aunt's estate. It's a simple estate. She does not have a trust. She had a will. The amount of money sitting there is waiting to be distributed, but we're going through the probate process. This has now been month 3, and we're still not even halfway through the probate process. So if you have a son or a daughter who you want to get some money right away to, a trust could potentially help you facilitate that quickly, because with the trust, you bypass all this probate stuff.
Yep.
But all right, so the answer to that question was no, don't leave the minor $1 million.
Without at least having some sort of
Custodian or guardian or something.
in
Some
place.
sort
for
of
them.
plan in place. Brooke, what's the next question?
Hey there, RFL Show listeners. Did you know that 97% of Americans associate the word financial advisor with simply investing money? But sadly, there is one key piece of information most retirees do not realize until it's too late, and sometimes they miss it altogether. And although retirement is this great emotional victory, sadly, it's actually the beginning of the most treacherous part of your financial life. If you're considering working with a fiduciary who works exclusively with retirees and those nearing retirement, go to aimassessment.com. That is AAMassessment.com. Schedule a complimentary one-on-one visit with me. Ask questions about your retirement situation. Learn more about our trademarked Aim Retirement System and see if we may be a good fit for you. It all starts here with the conversation. AIMassessment.com.
Okay, this one's multiple choice. What is a medical power of attorney and or advanced healthcare directive? A will you update every year. B, a document outlining your funeral wishes. C, a legal directive for your medical care if you're incapacitated. And D, a fun will you write while sipping wine.
So we're talking about power of attorneys, which go right along with, a will or a trust. These are documents that you put in place to help, things go smoothly while you're still around.
Yep.
So we have financial power of attorneys, but in this case, we're talking about a medical power of attorney, healthcare power of attorney. This is something that, it basically directs how you want things handled while you're still around.
Yeah.
Yep.
I think that's a big distinction that people don't understand. We've been talking about wills and trusts. Both of these documents dictate what happens after you're gone. I've often said that perhaps a document that's even more important is the power of attorney documents, because when you are still around, sometimes those decisions that you need to put upon your loved ones, the people that you trust, can be more important while you're still alive than when you're gone. So we talked about just now, Brooke said advanced healthcare directive, medical power of attorney. What's an example of when you would need a medical power of attorney?
I mean, there's times where a doctor may not want to listen to what the spouse is saying that their loved one would want. So with that power of attorney, you can say, this is what he said he wanted or she said she wanted. And, I have the right to make that decision.
Absolutely.
So.
And I know I go back to my aunt, was with her at a lot of healthcare visits. First question they ask, who's the medical POA here? Who's responsible for the health care of this person? Because if there's nobody, ultimately it's the doctor's responsibility to give the best care that they deem possible.
Right.
And a lot of times I like to use the example of a husband who goes into a coma. Doctor says, I think we should do this. And the spouse who's been married to that person for 50 years says, like Andrew just said, no. My spouse and I have been together for 50 years, and we decided, we've talked about this, we want this to happen. If the doctor doesn't have a power of attorney in hand, he has the right to make the decision, despite the fact that you've been married to this person for 50 years.
Yep.
And it can be more than just sitting at the doctor, right? You can give additional information about how you want to be treated, what your preferences are, what your beliefs are.
Access to your medical records, if you're helping somebody that is not able to access that on their own. And same with the financial, it's a similar thing, but if you aren't able to access your accounts or get information on even your taxes, having a financial power of attorney allows another person to help you out and gain access to your accounts for you. So if there's someone you trust, it makes sense to have somebody on file that can help you in a time of need.
And I also wanted to add really quick, if you even have a college kid, once they're in college and they're 18 years old, even if you're there paying for their health insurance, you don't get to know about that stuff. So without that power of attorney, you're in trouble.
Right.
And like you can't see your kids' grades. That's
I know, even though you're paying the bill.
It's like, okay, so let's be clear. If there was one thing so far that you would take away from this podcast, every person, I believe, should have, at a minimum, 3 legal estate planning documents. Every person should have a power of attorney for their medical wishes. Every person should have a financial power of attorney for people who they trust to help them with their financial needs or any type of other legal issue if for some reason they're incapacitated. Every person should have those POAs. So if you're married, that's 2 times 2 equals 4. But the third document is a will. And as we decided or said, and maybe even a fourth document would be a trust. Power of attorneys help you when you're still around. Wills and trusts help you when you're gone.
I think we should talk about gifting. We, whether it's charitable gifting or gifting to your loved ones, a lot of the times your legacy means how you want to leave your money behind. So an important thing, while you're still living, you can gift your money while you're still alive, whether it's to charity. We have clients that gift their RMDs, and it's a tax benefit as well, but also gifting your money while you're still alive can be a good legacy. People think of while they're gone as their legacy, but you can start doing things like that now too.
Yeah, I have clients all the time that say, you know what, I want to give this while I can see them enjoy it.
Yes, I hear that a lot too. I think that the gifting aspect of estate planning is often overlooked. I agree with you. There's a lot that should be considered. I think some people don't think about it until it's too late. Some people like me think about it too much, too early. Not like I'm planning my own demise, but I was just looking today. I have like a 15-step process of what I'm going to do now between now and the end of life. So, but I do think that the reason we deemed May Estate Planning Awareness Month, the bigger picture is that for a complete financial advisor, I think about just some basic things. Investing, Social Security, taxes, estate planning. And if you kind of are insular and you look at just any one of those 4 things on its own, really how difficult is a tax return? Obviously, I don't mean to put down my brethren, the CPAs, but I mean, let's be honest. Some people, a lot of people, can go and get their tax return done free or pay $35 or $45 at intuit.com. By itself, it's a commodity, perhaps, in some cases. It could be argued that investing on its own is somewhat of a commodity, perhaps. It could be argued that Social Security can be boiled down to a simple calculator online where as long as you know when you're going to die, the answer is clear. And honestly, most attorneys would tell you the X's and O's of a trust or a will are pretty straightforward. I mean, you can go to legal.com or whatever it is and pay $500 and get a will completed for you with those power of attorney documents. And so the bigger thing for us, this is the Retirement for Life show. We are Sear Financial Wealth Advisors. We are telling people that we are going to help you with your full, entire financial picture, be the general contractor of your financial life. And the amazing thing that happens is when you take 4 or 5 different simple commodities and you try and put the pieces together, that's where it gets difficult. And the magic happens is when you put all of these pieces together. For us, we found that the estate planning piece was, as I said at the beginning of the show, the most overlooked part of that. And so I think it's just important for us to bring awareness to estate planning.
Mm-hmm.
People need to focus more on this because it has equal importance and weight to all those other things I mentioned, and perhaps more weight.
Mm-hmm.
So,
So if you have like an old will out there, make sure you review it and it's, according to your wishes. Same with beneficiaries on all your accounts. That's one of the easiest things you can do, but oftentimes it's overlooked or out of date. So keep an eye on your estate planning and make sure your wishes are going to be followed through when you're gone.
Yeah, I think a lot of times we are responsible with that stuff when we have kids. But, a lot of times once they're out of the house, we forget we don't need to list a guardian anymore. We need to update this stuff.
Can we play a game really fast?
Yeah.
All right. You're the customer. I'm you. I'm Andrea, the financial advisor, and you've asked this question a million times. So just give me kind of a typical answer.
Mm-hmm.
Do you have a will, customer?
I think so. I'm not sure where it is.
Okay.
Might be
That
30 years old.
That answer means get your stuff looked at. Maybe it needs updated.
Yeah.
I'm going to ask you another question. What year did you get that will done?
Oh, gosh. Maybe when I first had my daughter.
If you don't know the answer to that question, here's another question. Hey, Mr. Customer, where is the will located?
I'm not really sure. I think it could be in my safe or maybe even the safety deposit box.
I don't know. I don't know where the key to the safety deposit box
Here's
is.
another question. Hey, Mr. Customer, good to see you today. Do you have a power of attorney?
Oh, what's a power of attorney?
Or I do have it. It's not on file with any of my financial institutions.
Or I think I have it?
Right.
Mm-hmm.
Okay. That's not the right answer for who gets your millions of dollars when you die.
Mm-hmm.
That's not the right answer when you have 3 children. You want to make sure that they're treated a certain way.
Yep.
That's not the answer when your husband maybe is prone to heart attacks and could end up in the doctor's office next week and you don't even have anything that can manage his health care.
Mm-hmm.
Make sure, even though Brooke, can you write whoever's in charge of Estate Planning Awareness Month and tell them that they should make it October and May?
Yeah.
Let's do that.
Okay.
Okay. So it's official now. May and October are Estate
Right.
Planning Awareness Month, and it's May. So make sure you're aware of your estate plans.
Mm-hmm.
Investment advisory services provided by Sear Financial, Inc., SEC registered investment advisor. All content on this podcast is for information purposes only and should not be considered investment, legal, or tax advice. Material presented is believed to be from reliable sources, and no representations are made by our firm as to another party's informational accuracy or completeness.